Hearing the appeal Hastings against Finsbury Orthopaedics Ltd and another.
Yes, I swear.
Well, please, my Lord President, my Lady and my Lords, I appear on behalf of the appellant, I'm learning for Mr Milligan of Queen's Counsel, and Miss Connolly, who sits behind me, and Mr McBrearty of Queen's Counsel appears on behalf of the respondent with Mr Antown of Queen's Counsel, Mr Myhill and Mr Campbell. My Lord, I look on in trepidation because you've all brought out your key documents folder, and I have to confess I've said core bundle, pages 1 to 2000, and I've stuck to that religiously, and I haven't given the reference when I'm going to make my oral submissions to the page in the key documents bundle. I don't know if that's remiss of me.
Our core bundle is paginated.
Core bundle 1 to 2005.
Yeah.
It's core bundle as opposed to the blue key documents bundle. That's the
I
one.
see. No, we only have the key documents bundle. Everything else we have electronically, and so we need the MS number or E numbers.
My Lord, yes. I was going only to refer to core bundle electronic pagination.
Yeah.
I hope that's okay.
That's fine.
And
That's
if you're about to dip into the key documents bundle and hope that I was going to take you to the exact page, I may struggle.
No, that's fine. And we also have a couple of additional documents which came in late.
Yes, they did. I apologise for that.
No, that's
when I found a phobia, I thought you should see it, and the other one was the opinion of the Advocate General was missing. Well, my Lord, there's in our submission a single issue of law to be determined by this court, which is set out in our case, and that's page 87. So I'm now referring, as I say, continuously to the core bundle electronic page 87. I'll just call it page 87 at paragraph 20. Namely, where a product's removed from the market by the producer in the light of its concerns and those of the regulator and the relevant professional community, that its product is or may be unsafe so as to establish a prima facie case of defect, and the result of the producers removing the product from the market is that, and I would actually add, and in any event, the consumer cannot prove by statistical evidence that the product's defective, and nor can it be proven by statistical evidence the product is not defective, is Section 2(1)/Section 3 of the CPA, that's the Consumer Protection Act, subject to this appeal, and or Articles 4 and 6.1 of the Directive to be interpreted as meaning the product is defective. In our respectful submission, the answer to that question is yes, and the appeal should be allowed. In terms of my oral submissions, my Lord, I propose broadly to follow the order taken in our written case, and will shortly go to the 1987 Act, and then the factual basis for putting the issues of law, and then consideration of the European law and application of the principles established by the CJEU, and finally to the domestic law principle of fairness and its application in this context. But by way of further introduction, can I make the following short submissions? It's perhaps unusual, but it is the case that before this court there's a dispute between the parties as to whether the factual basis for putting the issue of law that I've already read out in the way that I have is made out in this case. So it's going to be necessary for me to make submissions, which in view of time constraints will be necessarily brief, to make good our case on 4 issues. They are, first, the identified defect relates to the intolerable revision rates for the Mitch Accolade product, which I will call the product. Secondly, there is a prima facie case of defect based upon the opinions and conduct of the orthopaedic community, the regulatory agency, and the respondent producer. And that evidence I may sometimes refer to as the prima facie evidence. It's the prima facie evidence that makes the prima facie case. Thirdly, the statistical evidence is what we call neutral. That is, it neither allows it to be proved statistically that the product was less safe than existing comparable products, that's non-MoM, metal-on-metal, non-metal-on-metal or comparable products, nor that it was not less safe than existing comparable products. And fourthly, the data available could not be used to prove statistically the case either way because the data set was too small as a result of the respondents having withdrawn the product from the market. And in relation to the development of our case on the issue of law, my Lord, can I just open in this way? The key issue in our respectful submission is whether the statistical evidence of Professor Platt undermines the prima facie evidence. In our respectful submission, it does not. There is, for instance, no evidence that any orthopaedic professional has changed his or her opinion. Indeed, the orthopaedic community continue to speak with one voice in saying that all large head MoMs are associated with an increased risk of early failure. Hence the implantation of MoMs, including this product, stopped by 2012 and at no stage later has restarted. The evidence of Professor Platt could hardly undermine the evidence of orthopaedic opinion and the conduct of the respondent and the regulatory agency when it is, as I've submitted and will seek to make good, neutral. It's simply unreliable, the statistical data, and so carries no weight to counter the prima facie evidence and the prima facie case of defect. And adopting any other approach would offend the European law principle of effectiveness, the necessity to interpret the Act purposefully to further the objective of consumer protection, and what we call the domestic law principle of fairness, not least when taking into account the appellant's inability to prove his case by statistical evidence is as a result of the defendant's actions in hastily withdrawing the product from the market. My Lord, with that introduction, can I turn to the Consumer Protection Act, which your Lordship and your Lordships and Ladyship will find at page 1482. 1482. First, can I invite the Court, and I'll just deal with this issue, to note the terms of section 1.1, so bottom left-hand corner, bottom part of page 1482. This part was enacted for the purpose of making such provision as was necessary in order to comply with the Product Liability Directive and shall be construed accordingly. As is well known, the 1987 Act was enacted to comply with the Product Liability Directive, which follows in the bundle. And so that in a pre-Brexit world, the Court was obliged to apply the Marleasing principle in any event. The significance of section 1.1 is that it's still a part of the 1987 Act, and so the starting point as a matter of pure domestic law is that the Court should interpret the Act to comply with the directive, because that's what Parliament directs and still directs by section 1.1. Can I now briefly detour into the European Union Withdrawal Act 2018, and I'm sure this is absolutely terra firma to the Court, but I can do it really in short order. If the Court kindly goes to page 1987. That's the start of the European Union Withdrawal Act 2018. And if you go on to page 1990, section 2, brackets 1, towards the bottom, I hope I'm not going too fast.
I'm sorry, which page?
Page 1990, my Lord.
Thank you.
Section
2, brackets 1. EU-derived domestic legislation, as it had effect in domestic law immediately before completion date, continues to have effect in domestic law on and after completion date. That includes this Act. And this Act is retained EU law within a definition you'll find at section 6, bracket 7, on page 1997. 1997, you're in section 6, bracket 7, and you'll see down towards the bottom, retained EU law means anything which on or after completion date continues to be or forms part of domestic law by virtue of Section 2, amongst others. That means that if you go back a couple of pages to page 1995, and the earlier part of Section 6, Section 6.2, a court or tribunal may have regard to anything done. Oh, that's, we don't need that.
Where are we now?
Page 1995.
Yes.
Section 6, brackets 3.
Thank you.
And Section 6, brackets 3 says, any question as to the validity, meaning or effect of any retained EU law, and I've just shown that that includes the CPA, is to be decided so far as that law is unmodified on or after completion date and so far as relevant to it in accordance with any retained case law and any retained general principles of EU law. And then Section 6.4 says, 4A, the Supreme Court is not bound by any retained EU case law, and Section 6.5 over the page, in deciding to depart from any EU retained law, the Supreme Court must apply the same test it would apply to depart from its own case law, in other words, where it appears right to do so. Now, there's no submission made by either party that it's right to depart from W and Sanofi Pasteur or Boston Scientific. So the net effect of all of that, in my respectful submission, is yes, we're post-Brexit, and yes, you have the power to disregard that European case law, but it's not an appropriate case for you to start to think along those lines. My Lords, if I go back to page 1482, which is the Consumer Protection Act, all I need for these purposes to do is to take your Section 2, brackets 1, and you'll see, so it's page 1483. 1483, Section 2, brackets 1, liability for defective products. And if you kindly read Section 2, brackets 1, you'll see that it suffices for the consumer to prove that damage has been caused by a defect in the product. That is the effect of Section 2.1. And if you kindly go over the page to 1484, down to the bottom, you'll see Section 3, brackets 1, headed meaning of defect. Again, if you kindly look at Section 3, brackets 1, you'll see that it says there's a defect in a product for the purposes of this part if the safety of the product is not such as persons are generally entitled to expect. And then 3, brackets 2 seeks to explain what's meant by persons generally being entitled to expect in terms of the safety of a product. So 3, brackets 2 directs the court, when seeking to identify the objective standard of safety, having so identified the objective standard of safety, the question for the court is this product compliant with that standard or not? Does it meet that standard? Just staying with Section 3, brackets 2, I would note that it's in Section 3, brackets 2, in relation to the issue of what is the objective standard, that Parliament says what persons are entitled to expect in relation to a product. In determining what persons are entitled to expect in relation to product, all the circumstances should be taken into account.
That's very interesting, but I thought it was agreed what the standard, the entitled standard was in this case.
Exactly.
Do we need to concern ourselves?
No, my Lord, no, my Lord, we don't. That's exactly right. I only do that because the respondent's case at paragraph 12, the reference for which is page 105, says, oh, when looking at defect, you must look at all the circumstances. And what Parliament has actually done is say, when you're seeking to identify the objective standard, you look at all the circumstances, but as my Lord Stevens so rightly says, that's not an issue in this case. It doesn't actually say you look at all the circumstances when determining whether this product is compliant with that objective standard. That's the only submission I needed to make in relation now, for this stage, to the CPA. If you're on page 1485, I do invite you to note the terms of the defence at section 4.1e, because I make reference to this later. So this is a defence, and so stated at 4.1, it shall be a defence for the producer to show, E, that the state of scientific and technical knowledge at the relevant time was not such that the producer of products of the same description as the product in question might be expected to discover the defect if it had existed in his products while they were under his control. The point being, and it's a point that's made by the Advocate General in the case that I put before the court yesterday, which was in our written case, the point being that there are defences and they are the only defences. And again, this is all very normal from a European perspective, because the directive provides for discrete, limited derogations, and as we know from a whole body of European case law, it's only those derogations from the principle otherwise that you prove a defect caused your injury, you win. My Lord, can I then turn, please, to the challenge to the factual basis for the issue of law which we say arises? And the first issue is identifying a defect in the product. Now, as set out in our case at paragraph 1b, the reference for that is page 82. I mean to rush you if you want to turn that up. It's 1b, page 82. Our submission is that prima facie evidence goes to establishing that there was a higher than tolerable revision rate for the product. That's the defect of which we complain. And this answers, we say, the respondent's complaint at paragraph 56 of its case that we haven't identified the defect. That's page 121. If you can kindly go briefly to page 121. You're now in the respondent's case. I mean, it may be, as I say, you choose to go to your key bundles, in which case I'm afraid I'm going to let you find it because I don't have the page, but it's paragraph 56 if you're going to the hard copy. Otherwise, it's core bundle, page 121. At 55A, the respondent goes on to raise the issue of whether causation is established in the individual case. In avoidance of any doubt, that is out with the scope of the proof before Lord Tyre. See the last sentence of paragraph 3 of his opinion, the reference to which is page 180. So page 180, para 3. Last sentence, all matters specific to the pursuer, including issues of causation, as well as quantification of loss, were excluded from the scope of the restricted proof. So that's just not an issue that's before this court. The second issue, that there is a prima facie case of defect based upon what I've labelled as the prima facie evidence. I make these submissions against the backdrop that the respondent put centre stage in its written submissions its complaint that there was no relevant orthopaedic evidence. That's page 99, paragraph 2c. And when you go to page 132, para 72, 6a, they say, properly analysed, the prima facie evidence is limited to the withdrawal from the market and the MHRA alert. In other words, the orthopaedic evidence just doesn't count.
What document is...
My Lord, it's their case. I mean, their case.
Para 72,
72,
6A.
6A.
Yes,
It's at the bottom of page 132.
Thank you.
Of the core bundle, but not what you may be looking at, my Lord. And you'll see that's what they say. In line with what they've said at para 2c, they say the orthopaedic evidence doesn't bite at all. They also say the withdrawal from the market by the respondent was not linked to concerns about the product, para 2d.
Well, are you saying that what they say in 72(6)A
Is wrong.
is wrong.
Yes, my lady, and I will come. I'm just showing.
Oh, okay.
Yes, my lady, absolutely. I will go straight to the orthopaedic evidence. I'm just identifying why I'm going to it, because it's being put in issue. So is the withdrawal of the market as having any link to any concerns about the product. That's para 2D. The regulatory conduct is said to have been made on the basis of statistics taken at face value. That's para 72(6)A again. But I do note that the respondent is careful not to say in terms that there was no prima facie case of defect. They haven't actually said that. They've made these submissions, but they haven't gone as so far as to say there's no prima facie case of defect subsequently undermined on their case by Professor Platt's evidence. And now in response to Lady Rose, can I start with the orthopaedic evidence?
Before starting with the orthopaedic
Yes, my lord.
evidence, was there any finding by the Lord Ordinary that there was concerns amongst the orthopaedic community?
Yes, my lord.
Right.
Absolutely. Absolutely. The orthopaedic evidence is particularly important before I turn up those references from Lord Tyer's opinion, because in a context of a hip replacement, the patient is reliant on the orthopaedic surgeon to advise on whether to have a hip replacement, and if so, which prosthesis to use. So they really take centre stage. And the evidence of the orthopaedic community, this isn't a Bolam-style case in which we're focusing on a particular rational body. We're looking at the whole orthopaedic community. That they speak with one voice for these purposes. The orthopaedic community is the whole orthopaedic community. And I can break it down into three parts. The evidence of concerns up to 2012, the ongoing concerns of the orthopaedic community beyond 2012, and the orthopaedic evidence that informed the regulatory agency. Up to 2012, Lord Tyer set out how the orthopaedic community was concerned about revision rates.
When you talk about the orthopaedic community,
Yes, my lady.
do you mean orthopaedic surgeons?
Yes, my lady.
Or a wider community?
No, my lady. The reference to an orthopod is invariably a reference to an orthopaedic surgeon. All orthopaedic doctors are orthopaedic surgeons.
Right, but
so it's the orthopaedic surgical community, my lady.
Who are actually practicing
Who are at
surgeons.
what you might describe as the coalface, my lady. They are in the business, hence that prior submission I've made. They are the ones in the business of advising patients, have a hip replacement and use this prosthesis.
Mr. Webb, just going back a step for a moment.
Yes, my lord.
The prima facie evidence on which you rely,
Yes, my lord.
does that all go to time to revision?
Yes, my lord.
Thank you.
Absolutely.
That was my understanding.
Absolutely, yes. That's our case and defect. I'm taking you to that evidence.
Yes, thank you.
So up to 2012, Lord Tyer was set out how the orthopaedic surgical community was concerned about revision rates at paragraph 82, which you'll find on page 208. Para 82, 208. The reason for the general decline in MoM THR, that's through hip replacement, sales was that concerns had begun to be expressed amongst orthopaedic professionals about revision rates and potential difficulties in carrying out revision operations. And so in response to my Lord Lloyd Jones, that's additional, but we are focusing on the revision rates. And see the rest of the paragraph, but with time constraints, I'm more a case of taking you to the paragraphs and proposing to go through each one in turn, if that's okay. If you go on to page 231, para 122 at the bottom of 231, the argument for the pursuer is founded strongly upon the fact that in the wake of the orthopaedic concerns and MDAs to which I've already referred, surgeons stopped recommending MoM THRs and they disappeared from the market. Nothing has changed in that regard since 2012. Bless you. In a 2016 paper, Matarau et al. Observed that the unacceptably high failure rates of stemmed MoM THAs are undisputed, with these devices no longer implanted worldwide. Drop down a line as Professors Bruce and Pandit, those are the orthopaedic surgeons, called on behalf of either party, put in their joint statement, in 2019, there's universal agreement that large head MoMs are no longer used and no longer available. And that accords with the assessment in 2013, which is quoted at paragraph 87 at page 211. If you kindly dip back to paragraph 87, page 211. I think the court has that. A useful summary of the thinking of orthopaedic professionals as at 2013 is provided in a review article by Mellon, Little and Pandit. And then dropping down to the second paragraph quoted, however, whilst there's evidence that MoM works well in active young men, the failure of MoM in women and metal-on-metal THR in both sexes are significantly higher than expected. And so it continues, and you see again, he says in para 88, since 2012, the implantation of MoM THRs has stopped altogether. And then if you kindly go to page 258, to paragraph 164. So 258, if you're core bundle, I'm afraid freestyling it if you're not, but paragraph 64, down towards the bottom, I have noted, this is Lord Tyre, I've noted the view of Professors Bruch and Pandit expressed in their joint statement that it is a consensus opinion now among orthopaedic surgeons that all large head MoM implants are associated with an increased risk of early failure than comparator non-MoM implants. And that goes over the page. You'll see Professor Bruce stated in the course of his oral submission he would regard any MoM THR with a large metal head on a very small taper as a risky combination and product. That's summarised in the Statement of Facts and Issues at paragraph 92, which is on page 67. Page 67, but yes, but not if you're in the key bundle. But para 92, it's page 37 of the SFI itself. No large head MoM THRs are now used anywhere in the world, although metal-on-metal hip resurfacing, but that's something different, is still carried out in limited circumstances. The orthopaedic community stopped using large head MoM THRs in 2012 due to increasing concerns about their performance. Sort of summary of the position. And this product, the Mitch Accolade product, is one such large head MoM. So, and contrary to the respondent's case, all this evidence that I've taken the court to is relevant to the product. As regards the orthopaedic evidence that informed the regulatory agency, the regulatory agency was itself guided by an expert committee, and you see this from the opinion of Lord Tyre at paragraph 82, which is page 209. (209) of the core bundle, electronic bundle. Paragraph 82, last sentence, please. An expert committee set up by the Medicines and Healthcare Products Regulatory Agency, the MHRA, in April 2010, further developed awareness amongst clinicians, patients, and others. And that expert committee included orthopaedic experts, much as one would expect. And for that, I'm going to take myself away from the two bundles, which are, well, for me, the hard copy two bundles, into another one just at once. It's page 521 of the core bundle, please. So electronic 521. And what I'm taking you to is the medical device alert issued by the regulatory agency, the MHRA, in April 2010. So it's page 521. And the court can see this is in relation to all metal-on-metal hip replacements, which includes the product. The problem was identified. The MHRA has received reports of revision replacements involving soft tissue reactions. There's action in the right-hand column of follow-up. And if you kindly go over the page to 522, under the heading at the top, problem, if you pick it up on the third paragraph, following extensive consultation with orthopaedic experts and using information from the NJR, the National Joint Registry for England and Wales, the MHRA is issuing this interim advice, etc. And next paragraph, the MHRA is continuing to monitor the situation in consultation with orthopaedic experts and may issue further advice. And as we know, it does issue further advice, and the further advice that it issues includes advice in relation to this product. If you just go to 542, you see that. That's the April 2012 MDA medical device alert saying, do not implant this product. Page 542. So in other words, there is a unified orthopaedic body of opinion, which not only is, again, MoM products on grounds of revision rates, but has continued to maintain that position, and there is orthopaedic opinion which has guided the MHRA. So turning to the regulatory agency evidence, it issued, as the court's just seen, in April 2010, the MDA for all MoM prosthesis, and that includes the product, because it is an MoM prosthesis.
I'm sorry to interrupt you. I'm just wondering where we're going with this, because we're not reviewing the evidence.
No, my lord.
So I'm not quite sure why we are reviewing the evidence.
Well, my lord, as I say, it's slightly unusual to turn up in the Supreme Court and say it's an issue of law, but I've got to go and have a look at the facts first. But I'm put in that position, and so I need to show the court. In fact, I could almost go just to para 124 of Lord Tyer's opinion, in which he recognises the prima facie case.
Because I mean, the danger is, I mean, you're taking us to particular parts of the evidence, but there was a colossal amount of evidence.
My lord, but it's in the statement of facts and issues. I could do it rather than I happen to take you to that particular document.
Yes, I mean the trouble is with cherry picking, essentially. I mean, we know that when we know what evidence
Lord, yes, but it's not
and what findings he made.
It's not cherry picking, my lord, respectfully. I would understand that concern or complaint, but it isn't cherry picking. It's been put against us in the written case in the Supreme Court. There's no orthopaedic evidence to support your prima facie case. I've taken you through Lord Tyer's opinion, essentially, and said, look what he's just said. So that's not cherry picking, my lord, in my respectful sense.
I mean, it's going to invite Ms. McBrearty, effectively, to go through the other parts of the evidence that support.
There aren't other parts in relation to orthopaedic evidence. I'm not missing out sections in relation to orthopaedic evidence.
Well, I mean, you know there's a lot of evidence which the Lord Ordinary considered undermined the NJR data. He took evidence from Professor Pandit, for example, about how, looking at the matter later, he now was reconsidering what he'd said at the time.
No, my lord. The orthopaedic evidence speaks with one voice. And I've taken you to relevant passages. It's a fix, my lord, but somewhat.
The problem is, yes, clearly there was. Everyone took fright and thought that what they had hoped would be a solution to intractable problem with the wearing out of these hip joints, that this might be that solution, and then everybody took fright and thought that it isn't. But the question is, on what was all this orthopaedic opinion, this consensus of the orthopaedic community, what was it actually based on? What statistics was it based on? Was it anecdotal evidence? Was it some kind of statistical analysis? And that was what the Lord Ordinary is looking at. Yes, everybody suddenly thought and formed the view that there was a higher failure rate, but was there in fact a higher failure rate? And from what I see, what he went on to analyse is what was everyone basing this view on? And he said, in fact, when you look at the statistics, it wasn't based on anything very sound. So are you saying that all this community view that was formed was based on something other than the information that was before the court and analysed by the Lord Ordinary?
Yes, Melanie, absolutely. What the position is, you have an orthopaedic community who make an assessment. The assessment an orthopod makes is not the same as a statistical assessment. An orthopaedic surgeon is not a statistician, nor does the orthopaedic surgeon claim to be. The orthopaedic surgeon is charged with the grave responsibility of making an assessment as to whether a product is safe for his or her patient. The orthopaedic community decided that product was not safe. The orthopaedic community has not changed its opinion.
No, but on what basis did they decide that?
On the complex basis that a surgeon who operates, performs this work, takes into account the revision rates at the time that are being publicised, but a range of factors, makes a considered assessment. That is a considered orthopaedic assessment. Can I explain?
If he has a rational basis for acting, for example, you could have let... If he has a rational basis for acting, it should be capable of being explained. And if he doesn't have a rational basis, then why is one interested in what he does?
Oh, my Lord, that's respectfully and very quickly to dispose of a body of orthopaedic opinion on the basis that the only evidence is evidence of statistics. And it doesn't work that way, because which I'm going to develop in relation to the hazard of saying it has to be statistics or bust, because effectively that's what's being said. What's being said is, well, and this is the case against this, which, as I've set out early doors, is the case I need to meet, which is that all of this body of evidence, this prima facie evidence, is simply undermined by statistical evidence. If I could pursue that, if there was statistical evidence that said it is crystal clear that the revision rate is, say, 5% after 10 years, that is underneath the 10% per the NICE guidance after 10 years. And if, in the light of that, the orthopaedic community said, well, we've now seen the statistical evidence after 10 years, we accept that and we renege on the views that we previously held, that would be a different case. That is not this case. There is no evidence that the orthopaedic community has reneged on its opinion. That is why I've taken you to the evidence of the orthopaedic community, which is as one, and says we were concerned, the product, the regulatory agency was concerned, the respondent was concerned, the product was pulled from the market in 2012, it has not returned, and no evidence has been adduced before the court below, no evidence that the orthopaedic community now recognises it was wrong. And the reason for that is not difficult to define, because, as I have made a submission already and need to make good on it, the statistical evidence is neutral. It's invalid. There isn't statistical evidence that undermines the professional assessment of orthopaedic surgeons. What you have is a statistician, Professor Platt, who says it is not possible to make a reliable statistical assessment. That evidence does not undermine professional opinion. The professional opinion may or may not be statistically capable of justification, but when the statistics are unreliable, it's never going to be capable of statistical justification, but nor does it pull the rug from under the carpet of the orthopaedic surgeons, or you would have heard evidence, or Lord Tyre would have heard evidence to that effect, and no such evidence was led by the respondent.
But
That is
wasn't
our
it
point.
really for you to say the orthopaedic community's view is not affected by the National Joint Registry statistics? They form their view on the basis of X and Y, and have an orthopaedic surgeon to say that. But at the moment, I'm not sure what X and Y is supporting this community view if it's not the statistics.
My lady, surgeons don't exist in a world of statistics. They exist in a world of uncertainty. They are not statisticians. The product was brought onto the market without clinical random trials. Legally, we don't complain about that. It was not brought onto the market in a staged way. Legally, we don't complain about that. The product is then on the market. On the market, surgeons have assessments to make. They do not have the luxury at that point in time, or indeed ever in this case, not even now, of 10-year revision rate reliable statistics on which they can say, I can advise that it's appropriate to recommend this. So of course they're exercising their professional judgment, which this court is bound to respect. The idea the court can simply say, there's no reliable statistical evidence, ergo the professional opinion falls away, is deeply unacceptable.
But they're not expressing an opinion on the issue in the case, which is whether or not the entitlement was met, an entitlement in terms of a revision rate which was comparable to, or at least no worse than those of competing products.
Yes, my lord, that's exactly what they're expressing an opinion to in relation to, because their consensus concern is in relation to the higher than tolerable revision rates. Now, you can have higher than tolerable that is capable of being statistically analysed, and the answer is it's 12.6% or 23.2%, but you can also have higher than tolerable. And Lord Tyre was onto this, albeit I'm going to come to his not using the word entitled for expectation, but if the court kindly goes to para 124 at page 233. So this would be rewriting history, and I've no intention of doing that, and nor respectfully should this court, because Lord Tyre recognised all this. If you go to para 124, please, page 233. I accept that expression of serious professional concerns, followed by the issuing of an official alert and the withdrawal from the market of an entire range of products, constitutes powerful prima facie evidence that those products were not performing in accordance with, and he doesn't use the word, and I'm going to obviously address you in relation to this, but I say he is, or should be using the word, entitled before expectation. So if just for the moment I insert the word entitled, which obviously I've got to make good on, but if just for the moment I insert that, that is a recognition that this is relevant evidence, my lord. This is relevant evidence to the issue. Sometimes you cannot prove a case by statistics. This is the nub of the appeal. And if this court sits with a cold heart and says, bad luck, then we'll lose. But our case, based upon what we describe as good sense, before going to looking at the Consumer Protection Act and how it should purposefully be interpreted in line with the principles of European law, our case is that is not the proper approach. And there's no downgrading to be had of the body of evidence which constitutes the prima facie evidence which was adduced properly before the court, which I wouldn't ordinarily need to labour my way through, but did simply because it was being attacked.
Well, if the views of the orthopaedic surgeons were based upon the statistical figures as to revision rates, and those are subsequently proved to be incorrect, then is there any basis for those views being maintained?
My lord, that raises the interesting issues which I've sought to briefly touch upon.
I appreciate that orthopaedic surgeons may form a view on the basis of a whole series of factors, but is it for us to speculate, or is it for you to prove the basis upon which they formed their view?
My lord, it's neither way. There's no speculation involved. There is a body of evidence from the orthopaedic community, the regulatory community, and the defender's own actions that establishes a prima facie case of defect. My Lord Stevens then asks, if the statistical evidence shows that is wrong, that is not this case. But if the that was my example, if the statistical evidence showed it's 5% at 10 years, and if evidence from orthopaedic surgeons was then, well, we've seen that because we've two lead orthopaedic surgeons being called to this trial, we see that, we recognise now our concerns were misplaced, then one can understand the basis upon which the case would fall away. Interestingly, in that scenario, what if the orthopaedic surgeons maintained their opinions? What then? In our respectful submission, the answer then would be there would be a contest. There would be prima facie evidence from the orthopaedic surgeons, the regulatory community, and the defender's own actions. There would be what we might call rebutting evidence from the defenders in relation to, let's say it said it's 5% at 10 years. That's what the effect of the data was. And it would then be for the Lord Ordinary to decide, using the words of Lord Carlaway, where does the balance lie? In other words, to investigate why is the orthopaedic surgeon not shifting? Why is the orthopaedic community still of the view this product's unsafe? And it may be, as my Lord Rees says, that has a rational view. It may be it doesn't have a rational view. That would be the opportunity to investigate. But this is not that case. This is a case where there is a body of prima facie evidence, C para 124, in the opinion of Lord Tyre, and there is no counterweight. And the reason there's no counterweight is the example my Lord Stevens gives is not apposite to this case. The effect of Professor Platt's evidence is simply to say the statistical evidence is unreliable. In other words, you can't draw a statistical conclusion. But the case does not proceed, the prima facie case, on saying we need to prove 10% or more. It proceeds on the basis of the body of evidence which permitted Lord Tyre to infer there was a prima facie case. And this court is absolutely not well placed and shouldn't interfere with that. And that's the basis upon which we put our case. Now, part of what the submission I've made is to look at the effect of Professor Platt's report. And can I, going back now, go back to, first of all, though, the issue of what Lord Tyre said at paragraph 124. He was careful to say it is in accordance with expectation, this is page 233, which is not necessarily the same as performing in accordance with entitled expectation.
And the entitled expectation is no worse in terms of revision rate than existing products.
Yes, my Lord. And respectfully, that was a false distinction that Lord Tyre drew, because there is no dispute as to entitled expectation. See the observation of my Lord Stevens and indeed my Lord Kitchen just now. That's agreed. So entitled expectation is already an issue that's closed. Secondly, and respectfully, it is meaningless to refer to expectation that is not entitled expectation.
You have to explain that, certainly from my perspective, because
yes,
there were a number of expectations attaching to these products, and one that is described in the Lord Ordinary's opinion is that they would perform better than existing products, that they would have a better wear rate.
That's not how I'd understood that. It was him seeking to distinguish between expectation and entitled expectation in a tautologous way, recognising that this was prima facie evidence. It was his alternative and unnecessary way of saying it's prima facie evidence. In other words, the clock doesn't stop there. He says, I accept that up until 2012, you see the next part, he says, not necessarily the same as performing in accordance with entitled expectation. Assessing whether the latter has been established, I'm able to proceed with the benefit of hindsight to have regard to material now available, not available in 2012. That's what he was concerned with. He wasn't saying it's over. He was saying this is a prima facie case, but I've now got to consider the rebutting evidence. That's all he intended to say. And it's just tautologous. He achieved that outcome by saying prima facie, because that's what it is. Prima facie evidence.
Well, another expectation might be that they wouldn't produced the sort of debris that it had been found that in some cases these particular joints did produce.
My Lord, all of that in the broadest possible context may be right, but this is a specific context relating to the problem that's been identified, which was then reflected in the evidence of Professor Platt. So it all tracks through. When we've got a case based upon intolerable revision rates, we then turn to the evidence of Professor Platt, which is only about intolerable revision rates. So it may be that there are other issues floating about, but that's not what this is about. This is prima facie evidence in relation to intolerable revision rates. I took in our written submission, I referenced the recognition, if I can put it that way, by my learned friend Mr. McBrearty in the court below, that without the evidence of Professor Platt, we would have won. In answer to a question from Lord Woolman, it's in our appellant's case. We didn't have a response to it in writing in a respondent's case. It's an accurate record of what Mr. McBrearty said. I was listening to the hearing, and it was recorded by others as well. That's a recognition that we have a prima facie case in relation to revision rates. The only issue is, does the evidence of Professor Platt serve to undermine it, which is why I said at the outset, that's the key issue.
Well, in a way, you were relying on, you didn't lead any witness who had any experience of this product. You're relying on general evidence about metal-on-metal prostheses. The only evidence about this product came from Professor Platt. You were asking the judge to draw an inference that the evidence, such as it was, about MoM implants, enabled one to infer the characteristics of the product whose defectiveness was an issue. But as I say, Professor Platt's report was the only evidence, I think, which directly concerned the actual product we were concerned with.
My Lord, yes. And if Professor Platt's evidence was to the effect, statistically reliable assessment is the revision rate is X. If X was above 10%, we win. X is below 10%. Either, as I say, either you end up with a world where the orthopaedic community maintain their opinion and we have a contest between the two, or the orthopaedic community back down and say we accept that, and the pursuer loses. But that's not the evidence that we've got. And the mere fact of saying, well, that's the only evidence in relation to that particular product. I mean, it's off the cuff and not particularly good example, but if all this type of chairs are defective and liable to drop one of the justices down 1.5 feet at any given moment, the mere fact that this lot have been bought from a particular shop or whatever is neither here nor there.
Well, no.
It's evidence about all
You're talking
MoMs.
about a particular product. It's not a question of where a chair is bought.
It's all MoM products. That's the point. It's about a particular MoM product, one of a category.
Well,
and if the entire category has been criticised, my lord.
Well, in that case, if evidence is led against, well, in fact, it's agreed evidence that in relation to the particular product, if you want to, well, you're rather periling, you're placing your case in some peril if you lead generic evidence, which is simply about the general characteristics of MoM implants, as reported by the what you've taken us to, and you then have agreed evidence about this particular product.
Yes, my lord.
And you're inviting the judge to effectively, despite the existence of specific evidence about the product, to draw an inference from the general evidence about the whole genus of MoM.
My lord, yes, that's not in any. There's nothing remiss about that for the following reasons.
No, I'm not suggesting it's remiss.
No, but my lord, it touches upon the issue of fairness. The whole problem is that there weren't many of the product. So then to say, oh, well, you didn't call any evidence in relation to the product itself is exactly to identify the unfairness that would result from that line of analysis. And that's exactly our complaint. That's the whole point, my lord. You're asking us to achieve the impossible. There's no statistical evidence that's reliable that can establish 10% at 10 years. Not many of these products have been put in the market. I don't think you should win.
The difficulty is that you've pitched your case on a particular benchmark. You haven't pitched it on a benchmark of debris of a particular kind or failures producing particular serious injuries in the patients. Your whole case is pitched on revision rates.
Yes, well, that's entirely normal. That's how it should be. You're not required to establish the cause of the defect to succeed under the Consumer Protection Act.
But your whole case is now based on it. You did have a try at the trial to base it upon the effects of metal,
my lord,
biomechanics, and
my
so
lord,
on.
no, that wasn't the case. There were two cases that were run. One was revision rates, and the second was revision surgery would not go well. The revision rates case stood. The evidence that was sought to be adduced, the additional evidence in relation to the product producing ARMD and the biomechanical issues, was there, if you like, on a forensic basis to assist the court, but it was unnecessary because otherwise you are imposing hurdles on the pursuer additional to those carefully set by the Consumer Protection Act.
But if you had won on one of those, if you'd got home on one of those grounds, you would have won. If you'd shown that there was a susceptibility to fragmentation at the neck or whatever.
My lord, if one, for instance, goes to Lord Tyre, I think it's a paragraph 146, one doesn't win on that, because if you go to 146, got page 245, this was all linked to revision rates, and that's why that particular claim didn't succeed. If you go to the bottom of 245, so we're now in relation to the case which is analysed starting at 136. Is there a causal link between the design and creation of potentially harmful metal debris? And you go to the bottom of 146, para 146. In my opinion, the latter proposition does not at present rise above the level of theoretical possibility. On the basis of the evidence before me, in order to achieve the status of probability, it relies on drawing inferences from survival data, which not only were founded from Professor Gill, etc. So that's why it failed. It failed because it was still going through to revision rates, and that just came back to the Lord Tyre's analysis in relation to revision rates.
Well, I understand here that Lord Tyre was addressing revision rates, but in earlier sections of his judgment, he deals with specific complaints about defects in design.
Yes, ma'am.
He deals with reaction to metal debris, greater risk of adverse effect at paragraph 135.
Yes, ma'am.
Design defect creating a greater risk of early failure at 146, and worst outcome after revision at 162, which comes
Yes,
later.
These were designed to, if you go to paragraph 125 at page 233. I also accept as senior counsel for the pursuer submitted that although it was not necessary for him to show how or why the product in question is not performed in accordance with entitled expectation, it would add coherence to his case if he were able to do so. That's the basis upon which that additional evidence was adduced, to add coherence to the case, to meet exactly the natural judicial concerns expressed by my Lord Reid, the sort of response that says, well, hold on, I'm feeling like I need a bit more.
Could you so it was never put as a separate basis of the claim?
I do not believe it was put as a separate basis. It was attached to the case based upon revision rates.
The only issue before us is whether or not this product meets the entitled safety standard.
Yes, my lord.
And in order to prove that, you could prove it by establishing that it produces more metal, or that it is the wrong shape, or that it is uncomfortable or doesn't facilitate as much activity. You can prove it on a whole range of bases. You've pinned your colours to the mast of revision rates. That's as I understand it.
Yes, my lord.
Yeah.
Could you assist me with this, please? Insofar as you're focusing on the evidence of individual surgeons,
Yes, my Lord.
How could the evidence of an individual surgeon, looked at from his or her perspective, having regard to the particular patients that that surgeon is treating, provide any greater assistance in relation to revision rates overall than the statistics of which that surgeon's perspective forms only a part?
If you go to an orthopaedic, I was a medical student, and but if one goes to something like an orthopaedic symposium, they don't sit there and just say, what's the data? They sit there and they talk about their experiences. Absolutely. They form professional opinions.
The opinion of a particular surgeon may be that the failure has particularly terrible consequences, or it renders further surgery very difficult, that it causes great discomfort. All of those may add colour to particular sorts of difficulty associated with a failure. But in terms of rates,
yes,
failure rates, how can an individual surgeon's perspective provide evidence which is going to
quite normally and quite naturally? That's how it works. They're looking, they're going in, they're reoperating, changing it, seeing what's happening inside the prosthesis, making their assessment, talking to their colleagues, and we've got a community view in relation to this.
Those details would be captured by the general statistics, would they not?
My Lord, the general statistics, for the avoidance of any doubt, the statistics available at that time showed a significantly higher revision rate than was acceptable. That's the statistics up
yes,
to...
Yes, that's the point. The point is, was that really accurate?
No, my lady, nothing has happened to that body of evidence. That body of evidence is a part of the evidence that was out there that the orthopaedic community, which doesn't operate as a statistician, they operate as surgeons, they are different and avowedly so, was having regard to. When I come to the evidence of Professor Platt's evidence does nothing to that. It's neutral.
Well, with respect, does he not point out, and I'm sure you will come to this, that the figures were significantly affected by a number of outliers?
But, my Lord, the outlier issue is an additional feature that he addressed after the first feature he addressed, which is that the data set is too small to be reliable. If the data set is too small to be reliable, it is out, statistically speaking. So one is left with the evidence, namely the higher percentages early on, the orthopaedic community, and so on and so forth, the prima facie evidence.
My recollection, I may be wrong, there's a lot of evidence, but my recollection is that Professor Pangitt, and possibly one of the other experts, explained that looking at it with hindsight, the higher revision rates for the MoMs as a category reflected a lowering of the threshold for carrying out revision surgery, which was a reaction to the scare, if you like, about MoM implants.
There was an issue in relation to that was raised. It was one of the so-called confounding factors.
Mm-hmm. Yeah.
But the point is simply this: there is no proper statistical basis upon which the assessment could be made. That is the effect of Professor Platt's evidence. And if that is right, does that mean that the held opinion of orthopaedic surgeons, persisted in by orthopaedic surgeons to date, somehow goes away? Disappears. So it's you don't need, in fact, to have a reliable statistical base saying it's less than 10%. You just need not a reliable statistical base, in which case a product can be put on the market. It does not look to be going well. The product is removed early, deliberately so. It is never going to be possible to provide a reliable statistical analysis of 10-year revision rates. All we know is that the 36 people who had them needed revisions in 2 years. But the theory is that could be the first 36 statistically, and the next 999 would go through for many, many years without revision. So we wash our hands of this case and say it cannot be shown reliably, statistically. I don't know why the orthopaedic surgeons are making the assessment they're making, that with the first 36 it's unreliable and unsafe, and they're refusing to implant it. Of course we understand why they're making that, and they hold on to that opinion. That will suffice to win the case. Any other reproach offends deeply against the principle of consumer protection and the force of the Consumer Protection Act. That Lord Tyre was thinking this way is absolutely clear when one goes to the opinion of Lord Carloway at page 170 of the bundle, paragraph 70. His first sentence: the Lord Ordinary recognised the power of the evidence which pointed towards there being a defect in MoM prostheses generally. And of course, MoM prostheses generally...
I'm sorry, Mr. Weir.
Yes,
Is it Lord Carloway at paragraph?
What, 70?
70, thank you.
70. 71st sentence, my lord.
Thank you.
And if you kindly just go on then to page 174 to his somewhat condensed but critical paragraph 78. This is Lord Carloway. The pursuer responds to this by maintaining this case has not been based upon a consideration of statistical data but on the elements of the prima facie evidence. That may be so, but the question which the Lord Ordinary posed was whether that evidence had a sound underlying scientific or statistical base. Now that sentence captures what's gone wrong below. Absolutely captures it. So there was alternative prima facie evidence. But unless the pursuer was able to show that it had a sound underlying scientific or statistical basis, he was, per the outer house and per the inner house, bound to fail. That is patently unjust. Because there is no counterweight to the prima facie evidence. As he says, put another way, were the concerns, alerts and warnings based on accurate facts? Lord Ordinary held they were not. On what basis? Because all we've got is neutral statistical evidence. We've got unreliable, you cannot draw reliable conclusions from the statistics.
But you're inviting us to draw the inference, not just that surgeons stopped using this implant, because there might have been all sorts of reasons why they stopped using it. I don't know, it may have been a lot more expensive, or it may have been harder to get a supply, or they may have found it for some reason to do with them more difficult to deal with during the course of the surgery. There may be all sorts of reasons why surgeons prefer one implant to another, and why they then decide they don't want to implant it in their patients. But you're asking us to infer from this that the reason why they stopped implanting this prosthesis was because of its poor revision rates.
Well, this is not an inference. This is not...
All right, well, you say that that's what they say, that's the reason they gave.
My lady, I took you to page 258, para 164 of Lord Tyre.
Yeah.
In which Lord Tyre says, I've noted the view of Professors Bruch and Pandit expressed in their joint statement that it is a consensus opinion now among orthopaedic surgeons that all, and that includes this MoM, all large head MoM implants are associated with an increased risk of early failure than comparator non-MoM implants.
So that's what they're basing their decision to stop using this stop.
Yes, my lady.
But isn't the Lord Ordinary then entitled to examine how rational that decision is, or on what decision they've based?
Is he entitled to consider rebutting evidence? Absolutely. What is the content of that rebutting evidence? The evidence of Professor Platt, not the evidence of an orthopaedic surgeon who says, you chaps have got it wrong. You chaps need to review your opinions. No such evidence is adduced. All we have is Professor Platt. What does Professor Platt say? He says you cannot draw a sound scientific or statistical analysis because the data set is too small. Is that a rebuttal? No. Forgive me, my lord, if Lord Reed, if
I don't see why orthopaedic surgeons are particularly well qualified as compared with somebody who's actually carried out a statistical analysis of the revision rates of this product. I mean, it isn't a medical negligence case. We're not concerned with issues of medical practice. We're concerned with a question of whether this product is defective.
Yes.
And you've chosen to define defectiveness in terms of revision rates, and revision rates are inevitably a matter of the performance of this product as compared with others, which needs to be looked at by seeing what's the experience been. And for the reason that Lord Kitchen has explained, really all a surgeon can do is talk about his experience. And we have the evidence of an expert who's looked at the experience of, well, all the available evidence about what the experience has been.
Well, the MHRA itself relies upon orthopaedic expert evidence. I've taken you to the relevant document in relation to that. The idea that orthopaedic expert evidence can be downgraded in some way is in my respect, bizarre in this context.
If you could point to something other than the material on which Professor Platt based his analysis, if you could say, well, that the surgeon community had access to all sorts of other information that Professor Platt doesn't consider, and that is what entitled them or justified them coming to the view that they did. But that seems to be what's missing. What was it that led them to form their view if it wasn't the same data that Professor Platt examines?
Well, it's not.
It's just anecdotal, their anecdotal experience, or what? What is it other than the statistics?
I think an orthopaedic surgeon would be very offended by the idea that the orthopaedic surgeon is doing no more and no less than doing the best they can with the limited data set available. There's no. This is a prima facie case which, subject to the issue of entitled, on which I've made my submissions, which has been established by Lord Tyre. It cannot be undermined in this way by this court's reflections on the respective roles of orthopaedic surgeons and statisticians. The position is much more straightforward, and it's continuously said, well, let's look at what Professor Platt says. Can I look at what Professor Platt says? Because that may assist the court. So I can conveniently go to Lord Carlaway, paragraph 50, page 161. Where he sets out the defender's own argument, saying, paragraph 50, the agreed evidence of Professor Platt was that a comparison of the revision rates of the Mitch Accolade prosthesis and overall THR revision rates did not provide a basis for meaningful conclusions.
Well, I think the next sentence is important too.
Yes, and this is the defender's case, and I'm not adopting the defender's case. I'm just seeking to sort of pause at that point, if I may, before saying I've got to respond line by line to what they're saying.
Yes.
Just a convenient way for me to approach that. But it's why Lord Tyre found the case not proved and didn't make a positive finding that the product did meet the safety standard of comparable products. And you see that at paragraph 163 of Lord Tyre's opinion. That's page 257. So you see right at the bottom of 257, in my opinion, last line, in my opinion, for the reasons set out in the preceding paragraphs, the pursuer has not proved on balance of probabilities the survivorship was worse for Mitch Accolade product than for existing alternative products. And Lord Carlaway alludes to this in his own opinion, how it was a not proven case. And that's why it's not proven, because there wasn't statistical evidence from Professor Platt that said it's 5% or it's 9.2%, it just comes within, and it is 9.2%. There was no such evidence adduced. So that's what we mean when we say Professor Platt's evidence is neutral. The evidence does not permit, that evidence, Professor Platt's evidence, does not permit the court to find the product did accord with the objective standard or that it did not accord with the objective standard. And if we look at why that's the case...
Why didn't you call the regulator?
I beg your pardon, my Lord.
Why not call the regulator to give evidence that this product, it does not comply with the entitled standard?
Well, your Lordship makes a helpful, but after the
I'm sorry to
helpful,
ask the question.
in the way that one can approach litigation in so many different ways, and there's nothing quite like after someone else has litigated the case.
Don't worry.
Pointing out I would have done it differently, because there's the joy. Normally I reserve that to myself, but being shared now amongst the bench. But it doesn't matter, because of Para 124 we have the prima facie case. If you go to the SFI, the Statement of Facts and Issues, it's page 69, it's paragraph 98.
Sorry, could you give me the page again?
Yes, it's page 69 of the electronic bundle, it's paragraph 98. It starts on page 68, where it says the prima facie revision rate calculated on the basis of supplier feedback data for the UK was 23.2%, etc. Professor Platt set out in his January 2019 report how, with such a small number of Mitch Accolade hips implanted in the UK, there was a substantial amount of uncertainty associated with the cumulative revision probabilities, especially beyond a 4 or 5 year post-implantation. By 10 years, the total number of hips, at-risk hips in the UK data was only 98, leading to particularly sizable uncertainty and wide confidence intervals. Given the level of uncertainty associated with the estimates, it was his opinion that data as at 2018 could not be used to project long-term survivorship of the Mitch Accolade hip implants. Long-term is 10 years. So that's it. It could not be used. And why couldn't it be used? Because the data set was too small. You'll then see it carries on.
There are 2 points there, isn't it? The data set is too small, and also it gets smaller as the years progress. But the length of time doesn't necessarily hurt you. If there was a large number of implants in the first couple of years, and it was shown that after 3 years there was a 20% failure rate, well, then you know it's not met the guidelines, because that's not going to get better over 10 years. It's only going to get worse.
You don't know, my lady. That's the point, because on the analysis that's being promoted by the responder, it may be said, oh, well, actually, that's just a 3-year data. It would appear to say 20 years, and rational orthopaedic community has operated on this basis. But because it's shrunk after that, we cannot establish statistically what it is at 10 years. And it's and so we can't make the comparison with the NICE guidance. And then the follow-up to that on the responder's case, and the sort of thrust of the observation that's been made to me, is you lose. And that's exactly wrong, and your ladyship's identifying the problem. Because, of course, what your ladyship's doing is describing very much the orthopaedic community, which had regard not just to the limited data set for Mitch Accolades, but to the data sets in this country, Australia, New Zealand, in relation to other products. Professor Platt was homed in just on the Mitch Accolade, which is incredibly small. So that's exactly the sort of problem, my lady, of saying, oh, well, you've got to prove a sound statistical basis. You may not even establish it with 20% revision at 3 years, because someone can seek to say there are confounding factors, or the data set is too small, or both. And then, if the analysis below, in the courts below, is right, we'll still fail. So your ladyship exposes precisely the injustice about which we complain. So what's said at page 69, and I've set out that sentence, it was his opinion that the data at 2018 could not be used to project long-term survivorship. And then, additionally, there were confounding factors, and together the uncertainty and confounding factors made the data unreliable. So that is an additional factor. In the actual report of Professor Platt, he uses the word moreover. If you kindly go to page 272, Page 272, I'm not going to read para 11, but it flows from paragraph 11. If you then go into para 12 and pick up the last part of paragraph 12, this uncertainty, this is due to the small data set, see paras 11 and 12, also implies survivorship estimates for the Mitch-Accolade hip implants as of 2018 cannot be used, hence the language in the SFI, cannot be used to project the long-term survivorship of the product with reasonable certainty. Moreover, which is just a different way of the additionally, moreover, and again, due to the small size of hips in the data, survivorship estimates based on the data points are particularly sensitive to outliers. So the outlier, which was the big confounding factor, was a consequence of the small data set. The small data set was a consequence, and it's no good, respectfully, my lady, saying it could have been that lots of them were implanted. They weren't, and we're dealing with this case. We know a very small number were implanted.
No, the point I was making was that you were saying that because the product is withdrawn before the 10-year period,
Yes,
then that automatically means you can't tell whether it's met the guidelines, but that's not right.
No, I've never made that submission.
Okay,
It's
that
not
was
because
the only point
it's not because it's not removed for 10 years. If in the first 2 years 20,000 were implanted, you may have a sufficient basis, not for saying that the 3 years on the it's statistics or bust. That's not good enough. That even if it's 40% at 3 years, that's not good enough, because if the NICE guidance says 10% at 10 years, you've got to track it through, you've got to wait, you've got to see whether there's a reliable statistical basis for the initial figures at 40% at 3 years, because that's the effect of the judgments below. It is,
But how can it be if you implanted 20,000 of them in year 1, right, and 30% of them fail by year 3? How can anyone say, well, by year 10, only 10% of them will have failed?
By way of example, it could be said by a statistician, those surgeons, because that's the effect of the 2 outliers that we see, that the rates for this Mitch-Accolade at 3 and 5 years were well in excess of the expected rates, well in excess. And yet we end up in a position where we're told we have no statistical base of proving it, and if you take into account 2 surgeons, you can bring 23.2% all the way down to getting just under to a range that covers 9.8%. So who knows, my lady, who knows whether in fact it would then be suggested that there were
do we know how outliers were dealt with in the computation of the NICE guidance of the 10% over 10 years?
Well, you don't, I think you're pretty sure you don't take into account outliers. Outliers are defined as a definition where they're outside 2 bandwidths of the appropriate expected statistical outcome. So you don't take them into account. I think that must be right, because that's what Professor Platt's done. He said, if you then don't take them into account. So, my lady,
so wait a minute, let me just be clear that you accept that in arriving at the benchmark of 10% failure over 10 years, NICE will have excluded outlying surgeons.
I'm just checking with Leonard Friend, but I'm pretty sure that must be right. It would logically follow. They wouldn't want to say let's include the outliers.
But in any event, would it not be right to say that the bigger your population, the less problem any particular outlier is going to cause?
Oh yes, apologies if I seem like I'm fighting Lady Rose on this issue. I'm just trying to emphasise that yes, one can make facts sufficiently extreme, but actually, even higher much higher than expected revision rates of 3 to 5%. If you follow through the logic of the approach which has been taken below, you still don't get there. If you end up with a report from Professor Platt that says no more than there's not enough data for me to make a reliable statistical assessment. And because, as Lord Carlaway says, Lord Tyre is asking himself the question, is there a sound statistical basis? In other words, all roads lead to the statistician. We fail. And if this court considers that is a fair outcome, we fail. But it's remarkable that the court should so consider, because we have prima facie evidence, and the statistical evidence says nothing. It's neutral. It says, I can't help you. So it may be that at that point I need to move to the law, to show why, when faced in this quandary, there is only one response this court can properly and legally draw. It may be that I have to abbreviate this part in view of time and the very helpful interventions of the court. In summary, in terms of the proper approach to interpretation of the 1987 Act, may I make these 4 submissions? First, domestic law must not upset the balance set by the directive in terms, for instance, of the burden of proof and the scheme of strict liability for defect coupled with specific defences. Now, that's not an issue. So I can make it good, but it's just not an issue. Secondly, the domestic court must not interpret or apply its law contrary to the principle of effectiveness, that is, so as to make it excessively difficult or impossible to establish producer liability. Thirdly, effective consumer protection is a key objective of the directive, and where there is no conflict between that objective and other objectives of the directive, the domestic court should interpret the domestic legislation and apply its law so as to pursue the objective of consumer protection. Forgive me, it's quite long, but I couldn't really work out a way of shortening that. So there is effective consumer protection is a key objective, and provided it doesn't conflict with other objectives of the directive, you must interpret the domestic legislation and apply domestic law to pursue that objective. And fourthly, it is not necessary for the consumer to prove the cause of the defect or why the product failed. Can I then, without further ado, turn to what is easily the most important case in our respectful submission, and that's W and Sanofi Pasteur. And that's at page 1647. 1647. And the court will see, if the court kindly goes to page 1649, paragraph 9. I hope I'm not going too fast. Paragraph 9, that Mr. W was vaccinated against hepatitis B with a vaccine produced by the producer, defendant. And he then developed multiple sclerosis shortly thereafter, from which he subsequently died. And the case, see paras 11 and 12, that was pursued was that one was related to the other. The producer's vaccine had caused his multiple sclerosis. And that's in circumstances, if you go over the page to page 1650, paragraph 16, and I'm dipping in, I'm afraid, it's quite a big paragraph, but about 3 lines down, that there was no scientific consensus supporting a causal relationship between the vaccination against hepatitis B and multiple sclerosis. Does the court see that? It's para 16, my lord. 3 lines down. Does your lordship have that? And further on, about 7 lines down, according to multiple medical studies, the etiology of multiple sclerosis is currently unknown. So it can't be proven scientifically. And in the light of that, the question that was asked is set out at para 17, question 1, but it's converted in the way the CJEU do at paragraph 18 into how they like to frame it. And your lordship and ladyship will see at para 18, the question is one relating to both defect and causation. You see that from the penultimate line, defect and causation. And the question is applying French law, which was set out at paragraph 12, previous page, which is that you can prove a case based upon serious, specific and consistent presumptions. Was it sufficient to prove the case, to say it was really close in time, or was W to fail because there was no scientific basis for establishing defect and causation which run together? Because obviously if it caused multiple sclerosis, it's defective in that context. And then the important parts of this important judgment start early doors. Para 20 makes good my first submission, referring to Novo Nordic, which is that in matters regulated by the directive, there needs to be complete harmonisation. So you can't go claimant-centric, consumer-centric, or producer-centric if by that you're going to bust the burden of proof or the fundamental balance set by the scheme, which is consumer proves defect, set derogations. But within that arena, other things happen. And the first thing, see paragraph 25, is that there is, of course, principles of European law as it sets out equivalency and, relevantly for us, effectiveness. And para 26, for the avoidance of any doubt that the court well knows this, sets out what the principle of effectiveness is. It requires that those rules do not render practically impossible or excessively difficult the exercise of rights conferred by EU law. And then if the court goes over to para 27, so it follows from the Court of Justice case law the national rules governing how evidence is to be adduced and appraised must not be such as to undermine either the apportionment of the burden of proof, that's the harmonisation point, nor more generally the effectiveness of the legal system or the objectives pursued by the EU legislature. And then 28 to 29 say the French rules don't bring about a reversal of the burden of proof. And para 30 to 32 are essential reading. And may I invite the court, please, to read paras 30 to 32.
I suspect your opponents wouldn't quarrel with any of that. No. Or indeed with paragraph 41 of your case, of your written case.
My Lord, if
where you summarise the position.
Well, first of all, I'm not sure they can quarrel with it. It's because subject to the power of this court to disregard it. I've gone through CJU case law. It's there really to be followed. Secondly, if the court really feels that doesn't bite, then I'm in difficulties. To me, it's transparent that it bites, because what the effect of the observations of this court to date have shown is this court is essentially saying, can you prove your case by statistical means? You can't, you fail. Here we have the European Court say, be very, very careful before you put a consumer in a position where the consumer is disentitled from proving his case, which cannot be proved by medical or statistical means, by circumstantial evidence as they described it. And that's exactly what the effect of the decisions below has been. It's exactly the effect. It's saying, you want to prove a case, this is in relation to intolerable revision rates, you've established prima facie evidence, which is the exact equivalent to the French serious, specific and consistent presumptions being established. You've established your prima facie case, but because you are not able to establish, and it's not been shown you're wrong, it's just that you can't establish your right to a statistical standard, you fail. And the European Court is saying that offends. It offends against the principle of effectiveness, because that is keeping you out of proving a prima facie case you've established. If you haven't got a prima facie case, so be it. But we have got a prima facie case.
By prima facie, I beg your pardon. I'm sorry, I didn't mean to interrupt you. I apologise. By prima facie, you mean a case which, in the normal usage of the courts here, one would say is going to win unless it's answered.
Yes, my lord, and that's exactly
on the balance of probabilities.
Yes, my lord, and that's exactly why my learned friend Mr. Brereton, in answer to the observation from Lord Woolman, accepted that without Professor Platt's evidence, the pursuer would have won.
Well, no doubt he'll come to that in due course, but...
Lord, yes, and that's all in line with para 124. It's in line with how Lord Carlaway has shown that Lord Tyre did approach the case, which is that there was nothing really. We never came back to this expectation not entitled. There's no further analysis of that. It becomes a sort of throwaway remark because it disappears for the remainder of the judgment. And when you go, or opinion, and when you go to Lord Carlaway, as I've taken you to, he identifies at paras 70 and 78 how exactly what's happening is, yes, there's a prima facie case, a case that's then being rebutted by Professor Platt. Professor Platt's evidence, as I've sought to show the court, says nothing other than there can be no reliable assessment. It mirrors materially para 16 in W and Sanofi Pasteur saying the etiology is currently unknown and there's no scientific consensus supporting a causal connection. And when you go to the language, I'd forgive me if I express my surprise that this is deemed not to in any way impact upon the outcome of this litigation, because you've only got to go to the details of para 30. It should be stated, particularly since it's mentioned by the referring court, medical research neither confirms nor rules out. And that's exactly the case here. Statistical evidence neither confirms nor rules out. It's neutral. The link between administering the vaccine and the occurrence of the multiple sclerosis, the evidentiary rules that rule out any recourse to circumstantial methods and saying, oh, you've got a prima facie case, but now it goes, is no different from saying, I'm going to keep you out of it in the first place because you are ignoring it. When all that's happened is set against it is no more, no less than an assessment by a statistician that you can't draw statistically reliable conclusions from the data set. That's all Professor Platt says. And so here, the evidentiary rules that rule out any recourse to circumstantial methods, and it was very circumstantial in that case, it was, blimey, I've got multiple sclerosis shortly after I've had some vaccinations. In order to meet the burden of proof item Article 4, the victim is required to produce certain proof based on medical research of the existence of a causal link between a defect and the appearance of the disease, disregards the requirements resulting from the directive. And it's explained that's because of the principle of effectiveness and the need, see para 32, to protect consumer health and safety. So when someone's in this fix, and it's no good saying, well, they could have adduced this evidence. The whole problem arises because the data set is so small. So, of course, we're not going to be adducing surgeons who've got experience in the sense that there's such a small cadre of these, but they're within a bigger set of MoM prostheses, recognised to be prima facie defective. See the 3 strands of highly pertinent evidence on which we rely, including higher than expected, higher than tolerable revision rates, as it would appear, at 3 and 5 years. And then against that, all we have is Professor Platt saying, I can't tell you either way. I cannot form a reliable assessment on the data set. It's too small. The reference to the purpose of a fair apportionment of the risks inherent in modern technological production at paragraph 32 mirror the approach taken in Boston Scientific, which I don't have time to go through completely, but Boston Scientific, which starts, the judgment starts at page 163.
I mean, the second part of Sanofi went in the opposite direction, didn't it? They said, well, you can't also have a rule that says just because you got multiple sclerosis a month after having the hepatitis B injection, that we can there's a presumption of a causal link which the manufacturer then has to dispel.
Question 2, if you go to page 1654 at paragraph 44, isn't put in that way. It's put in the way. If you go towards the end of that sentence, you can read para 44, it then says, will always be considered to be established. And it's the always that's critical in that part. And so that's putting a case that we're not putting. That's putting a case that says, we've adduced our prima facie evidence, the door must close, we must win. That's not right. The defender has the opportunity and right to adduce its own contrary evidence, and that's what happened, and that's the evidence of Professor Platt. So we're not a question 2 case at all. We don't offend against that. And any suggestion that there's a reversal of the burden of proof is misplaced, because we have exactly respected the proper approach. to the burden of proof of establishing our case by the prima facie evidence. And you get a very careful and interesting analysis, albeit in a different context, of how that works in a domestic setting in the case of Drake and Harbour. Because if you go to Drake and Harbour, which starts at 1503, and to the judgment of Lord Justice Toulson as he was, that's dealing with the issue of causation, but it very nicely sets out the correct approach in his short judgment starting at 1509. His concern not to transfer the burden of proof at paragraph 26, so that he explains as an exact equivalent to our prima facie case and how the court should approach matters in his para 28.
But that, from memory, is where there is an established breach of duty.
Yes, my lord.
And the very harm which the duty would have guarded against has occurred.
Yes, my lord. Yes, that's a case on causation.
Yeah.
My lord, the point for these purposes is if you go to para 28 at 1510, Lord Justice Toulson says that where that's the case, exactly as my Lord Reid has explained, this will ordinarily be enough to enable a court to infer that it was probably so caused, even if the claimant's unable to prove positively the precise mechanism, for which I would interpose for this case. We have a prima facie case, even if we can't prove by scientific means. But then he explains, he says, that is not a principle of law, nor does it involve an alteration in the burden of proof. Rather, it's a matter of applying common sense, or what we call fairness. The court must consider any alternative theories of causation, so in that context, causation, but it's exactly the same point. Here, the court would then consider any alternative evidence adduced by the respondent, and before reaching its conclusion about where the probability lies. If it concluded that the only alternative suggestions put forward by the defendant are on balance as improbable, it will fortify the conclusion based upon the inference. It's my summary of it. And I'm just saying that's a good working example of how you're not offending against the principle the burden stays with the claimant, where you establish a prima facie case, you ask, the court is then given evidence by the defendant in response to it, and if the court is not moved by the defendant's evidence, it makes sense that it should follow the prima facie case, because it is not in substance being rebutted, but without offending at any stage, reversing the burden of proof, or maintaining it on the claimant. But yes, my lord, of course it's a different context, but that chimes here. And yet that is exactly what the observations of this court are threatening to achieve. And where is reading in with a view to protecting the consumer if it said, well, there isn't a sufficient database on which you can prove your case statistically, you've got a prima facie case, and yet you lose. That is hardly consistent with the drive, the objective, ordinary purpose of interpretation. And lest it be thought peculiar that we're in a world of interpretation at all, that's Sanofi Pasteur. Sanofi Pasteur, here's a question for the court. Someone has got their own circumstantial evidence to complain about a vaccine, but can't prove it medically. It could be the CJU say, this is a domestic problem, goodbye. But they don't. So their answer, if you go to page 1655, after the end, after para 57, their answer is a legal answer. It's an issue of interpretation. Para on the question 1. Article 4 of Council Directive 85, etc., on the approximation of laws, etc., for defective products must be interpreted as not precluding national evidentiary rules, such as those at issue in the main proceedings, under which, when a court ruling on the merits of an action involving liability to producer of a vaccine due to alleged defect in the vaccine, etc. So it's an issue of law. It's not just, well, this is what the domestic court chose to do in this case. Can't we just leave Lord Tyre to the assessment he chose to make? It's one of a reasonable range of assessments that could have been made by a first instance judge. No, it is not. It is an issue of law, or you are not honouring the objective of the Consumer Protection Act. And exactly the same thing happened in Boston Scientific. So Boston Scientific, again, is a fascinating case, because there you have pacemakers which are implanted, and some of the pacemakers, the concern is, are actually going to fail, but not all. Some of them. A consumer has a pacemaker removed in the light of that concern. That pacemaker is not checked and may itself not be defective. No one knows. And the question is put to the European Court, which again you can pick up in their judgment if you kindly go to page 1643. 1643, para 36. By its first question, the referring court's asking in essence whether Article 6.1 of the directive is to be interpreted as meaning that where it's found that products belonging to the same group or forming part of the same production series, such as pacemakers or implantable cardioverter defibrillators, have a potential defect, it's possible to classify such a product as defective without there being need to establish that the product in question has such a defect. And again, it could have been said, well, that's a very interesting question. Domestically, you can sort yourself out. But it isn't, because when you go to the answer at page 1645, Article 6.1, again, must be interpreted as meaning that where it's found that products belonging to the same group or forming part of the same production series, etc., have a potential defect, such a product may be classified as defective without there being any need to establish that that product has such a defect. And why is that the interpretation that's required? First, if you go to paras 37 to 43, it's a short section, but I am going to have to sort of go through it fairly promptly. First, by reference to what the public are entitled to expect, that's paras 37 to 40. And then if you go to paragraph 42, moreover, such an interpretation is consistent with the objectives pursued by the EU legislature, seeking to ensure in particular, as apparent from the second and seventh recitals, a fair apportionment of the risks inherent in modern technological production between the injured person and the producer. And that aim I could as well have put in with consumer protection, because it was mirrored when you go to para 32 in W and Snoffy Pasteur. It was both of those aims. And it's both of those aims because, of course, they march together. And reference to G or other case law in which it said all the objectives have equal status completely misses the point. The point is not do the objectives of a directive in the broadest possible way have equal status. The question is, in relation to the issue before the court, what are the relevant objectives and do they march hand in hand? So unsurprisingly, the Product Liability Directive, like every directive created, can only be created by the European Council when it's competent to do so, and it's only competent to do so when it's following the European project, which essentially involves the improving the free movement of goods, markets, services, and now capital. So of course, like every other directive, in its first recital, this Product Liability Directive says that it's aimed at improving the internal market. When isn't it aimed at improving the internal market? It has to be aimed to have competence. But the issue in W and Sanofi and Pasteur, the issue in Boston Scientific, and the issue here doesn't bite at all on free movement of goods. So it's not a relevant objective for these purposes. It bites upon consumer protection and a fair apportionment in circumstances where, of course, the relationship between consumer and producer is unequal. See for these purposes, although that is obvious, page 1969, the judgment of Novo Nordic, 1969, paragraph 32. That was a case regarding information in which the court set out that was out with the four walls of the directive, so it was legitimate for a domestic legislation to require the producer to give the consumer information. That didn't offend against the harmonisation principle. And it set out, as the Advocate General observed in substance in point 46 of his opinion, such national legislation is only intended to eliminate the significant imbalance which exists between the manufacturer of the relevant product and the consumer, to the detriment of the latter, and that context was as regards access to information relating to the product. But that, of course, applies generally, or you would not have found the CJEU referencing the objective of a fair apportionment when producing an answer which was, if I can put it colloquially, consumer-friendly. It was an answer favouring the consumer. The consumer was in a fix in both cases. Can I prove my case? I haven't actually shown this pacemaker is defective, or I have got no scientific way of establishing that this vaccine has caused my problem. And both times the CJEU comes down very clear terms and says this is a consumer protection or fair apportionment of risk between producer and consumer case. And you have to go consumer. And so all of these observations of the bad luck, you don't quite get there. In my respectful submission, simply inconsistent with the obligation of this court when interpreting the Consumer Protection Act. I've already made my submission that the consumer doesn't need to prove how his product is defective. For the avoidance of any doubt, that's set out in a Court of Appeal judgment called Ide, which starts at page 1570. It's a judgment of Lord Justice Thomas, as he then was. It's a case in which a handlebars on a mountain bike broke, and the defendant's case was it broke because you fell off your bike and then you broke your handlebars, and the claimant's case was the handlebars broke and I fell off my bike. And if you kindly go to page 1574, paragraph 7, down at the bottom, in determining 1574, down the bottom, in determining whether the loss or injury has been caused by a defect or by some other cause, although the process of reasoning may involve an explanation of how the defect was caused, the task of the court is simply to determine whether the loss was caused by the defect and not another cause. As is apparent from the first of the appeals, this distinction is important and can make the task of the court a simpler one, as no doubt Parliament intended. And Lord Justice Thomas was absolutely right to make that observation, because that's the point. Parliament has produced, following the Product Liability Directive, what should be a straightforward mechanism by which the consumer can establish his case and recognise to the CJ case law that I've taken this court to, how to interpret the basic requirement of defect causes injury in this context, and see also at paras 19 to 21, page 1580. The case based upon what we describe as a domestic law principle of fairness requires the court to analyse the cases that we've set out in our written case, which plainly, in view of the time limits, I'm not going to be able to go through in turn, to identify a common theme. And the common theme is that when it's the defendant's or defender's own conduct which operates to preclude the pursuer from being able to prove his case by a certain means, the court can and should seek out a fair solution rather than simply shelter behind the burden of proof. So here I am focusing in particular on the evidence that I've shown you in Professor Platt's report, that the reason we cannot prove our case as a sound statistical basis is because the product has been withdrawn, recognising my lady was asking a general question, but now focusing back to the specifics of this case, that is the consequence of the early withdrawal of the product. And applying that principle here is straightforward, because we did establish our case by alternative means, the prima facie evidence. And the only fair outcome in those circumstances is that that fair evidence should be respected, as opposed to arbitrarily downgraded. That is not adopting what the courts describe, including my Lord Lloyd Jones at first instance a number of years ago, as the claimant's benevolent approach. So using the time as I can I go to Wisniewski, which I'm not going to rehearse the facts, which are very well known about adverse inferences, and I've passed to the court the Afobe judgment in which Lord Leggett describes the Wisniewski, I won't call it principle, because he describes it as a matter of, para 41, ordinary rationality for the tribunal using their common sense. Themes that recur, which I say really are issues of fairness. In Wisniewski, if you kindly go to 1865, the source for Wisniewski and other cases was actually the observations of Lord Diplock in the Harrington and BRB case. And in the quoted passage from Lord Diplock, you'll see that that case involved not a breach of duty by the defendant, giving rise to this potential unfairness, but just legitimate tactical manoeuvring by a defendant in an adversarial system, not calling a witness who would be expected to call. And in the end of the first paragraph quoted from Lord Diplock, you see, but a defendant who adopts it, that's this tactical position, cannot complain if the court draws from the facts which have been disclosed all reasonable inferences as to what are the facts which the defendant has chosen to withhold. So we don't have evidence from orthopaedic surgeons that actually the orthopaedic community's views were misplaced. We don't have that evidence. We've got it wrong. That evidence is not before the court. We've got this non-evidence that you just can't prove it. Neither can nor can't. It just doesn't bite. It's not reliable statistical evidence. If you then kindly go from that to the Keefe case, Keefe and Isle of Man Steam Packet Company, which starts at 1708. This is a case involving noise-induced hearing loss where the defendant didn't keep a record of the levels of noise, making it obviously very hard for the claimant to prove his case. That constituted a breach of duty by the defendant, an additional breach of duty, but that's not relevant for these purposes. What's relevant, firstly, is to see that what lay in the analysis is the same, which is if you kindly go to page 1714, paragraph 19, Judgment of Lord Justice Longmore, which is to go back to the BRB and Harrington case. So it's an application, if you like, of the underlying same sort of principle, in which he says, if it's a defendant's duty to measure noise levels in places where his employees work and he doesn't do so, it hardly lies in his mouth to assert the noise levels were not in fact excessive. In such circumstances, the court should judge a claimant's evidence benevolently and the defendant's evidence critically. And then he refers to the BRB and Harrington case and says, similarly, where a defendant who has, in breach of duty, made it difficult or impossible for a claimant to adduce relevant evidence, must run the risk of adverse factual findings. To my mind, this is just such a case. And all this, respectfully, chimes precisely with the scenario we've got here. Because if the court says there's a roadblock, and the roadblock is your inability to prove a sound statistical basis, that roadblock has been created by the defendant. Furthermore, if the court kindly goes down to para 22, one of my Lord Reed's predecessors in this court as president, when in the Court of Appeal, the approach of Neuberger LJ in a case called Harrison BRB, as the court see that, so it's the bottom of 1714, is more apposite.
Claims for personal injury arising out of exposure to noise, vibration or other health risks, particularly with exposures over a long period of time in different circumstances, notoriously give rise to difficulties. While it may be dangerous to generalise, the cases demonstrate, and common sense and fairness require, and for common sense I say for me, fairness, that unless it's clear that decisive evidence would have been relatively easily available and there was no good reason why it was not before the court, it's normally wrong for the court simply to shelter behind the burden of proof and dismiss the claim. And that is what happened in this case. It is exactly what happened in this case. It is recognised by Lord Carlaway that it is unusual that it happened in this case, but Lord Carlaway forgives it. In our respectful submission, he should not have done. If we pick up the opinion of Lord Carlaway at page 168, paragraph 68. The pursuer raised a general point about what's to be expected in advancing a claim against what may be a substantial corporation. Sorry, my lord, I'm rushing you, but it's page 168, or it's para 68 of the judgment of the opinion of Lord Carlaway. Para 68, internal page 32. There is considerable force in the contention that the court should not impose excessively exacting standards on pursuers, whatever the nature of the case or the defender. It shouldn't expect the ordinary citizen to be able to mount an in-depth challenge which requires a detailed examination of defenders' manufacturing processes and subsequent product safety analysis, the type which might be seen in a commercial litigation to multinationals. And pausing there, the idea that it doesn't carry weight to have adduced evidence to say, from a consumer, Mr. Hastings, in court, to say, I had a product put into my leg, it came out early. The entire orthopaedic community speaks with one voice that the revision rates are intolerably high for this. The regulatory agency has consistently said don't implant. It has not revised that, it's not changed that. The 2012 MDA stands. The producer itself sent out a field safety notice saying do not implant, brackets, our product. And yet that doesn't constitute somehow ample and sufficient evidence, which is exactly what Lord Dyer found it did, prima facie evidence, and that one has to then get into the world of, well, really, what does an orthopaedic surgeon say? What's an orthopaedic surgeon thinking? That's sufficient. That is sufficient evidence, let alone before you doff the cap that says consumer protection, claimant benevolence, recognising the inequality of arms between the parties. And that's where...
Sorry for interrupting. I understand the case to be that the product is defective because it doesn't meet the safety entitlement.
Yes, ma'am.
And that is a claim in relation to both hips, because if one hip doesn't, one prosthesis doesn't meet it, the other one mustn't meet it as well. And I know this case isn't about what loss or damage flows from this, because it's solely about whether or not there's been a breach of the entitlement.
Yes, ma'am.
But I'm intrigued, and I cannot resist asking, what is the damage that is caused in relation to the right hip that was implanted in 2012 and is still there?
My Lord, I normally, I think my Lord Reid wrote an article for Council magazine saying, whatever you do, answer the question that you're asked by the bench. But I'm not going to answer a question that may impact upon others, including Mr. Hastings, but others. So I don't think it would be proper for me to address that. I understand the point that my Lord makes, and that lies for another day, because as your Lordship correctly recognises and observes, it's not one for today. So for that reason, I hope it will somehow slip under the radar in relation to the edict from on high as to how to advocate in this court. So, my Lord, on that rather sort of damp squib of an ending from my personal perspective, unless I can assist further, 2 minutes early, those are the appellant's submissions.
Thank you very much, Mr. Ware. We'll adjourn for a short time to consider where we are.
Yes, thank you.
Now, Mr. McBrearty, our impression is that there isn't really anything between the parties as to what the applicable legal principles are here. The way it's put by the appellants in paragraph 41 of their case is that the correct approach is for the domestic court to take into account all the evidence. Where the consumer has provided serious, specific and consistent evidence sufficient to make out his case, it is then for the producer to rebut or challenge that evidence as a matter of evidential burden, not a reversal of the legal burden of proof. The court is then charged with making its assessment as to the most plausible explanation. Now, if that approach is not in dispute, then we don't need to hear you on the law, but we would be grateful for your assistance in relation to other aspects of the case.
Very well, my Lord, yes. I'll do my best then to confine my submissions to that. If I may, and yeah. I think what I can say about paragraph 41 is that in the generality, I don't think I would take issue with that, subject to the fact that there may be, and one might regard it as a semantic issue or one might not, there may be a semantic issue as to whether or not it's helpful to talk about prima facie case and evidential burden, or whether in fact it's more helpful in a case such as this to consider that the Lord Ordinary was charged with looking at all of the facts, and really what's important at the end of the day is his ultimate evaluation of all of the facts and where it comes out in the balance. So there may be a semantic question there. On the question of the law, I wonder, and I don't want to be unhelpful.
No, not at all.
I wonder if I might address your Lordships just briefly on 3 cases. And I say relatively briefly because in my submission they do assist in my submission focusing what the problem is for the appellant in this case. And with that, I would then be able to, I think, to turn to assisting the court. And if in the course of citing these to 3 authorities, then if the court finds it unhelpful, then of course I'll be very much alive to that. The reason why I just wish to draw the court's attention to the 3 authorities is because in my submission at the heart of the appeal is the appellant's contention that the Lord Ordinary was obliged to draw an inference against the respondents and thereby to find that there was a defect in this product. And I emphasise this product because it was a proof about the Mitch accolade. And in my submission, the fundamental problem with this is that it amounts really to no more than a challenge to the Lord Ordinary's evaluation of the facts. And the reason why I just draw 3 authorities to the court's attention is because in my submission they encapsulate neatly the difficulty for the appellant here. And the first of those authorities involves, I think, asking my Lord Lloyd Jones to go back 10 years in time when he was sitting at first instance and hearing the claim by Mr. Shaw Lincoln against Neela Candon. It's a case to be found at tab 8.16. It starts at 1778 of the bundle. But if I could take your Lordships and your Ladyship to page 1796. 1796. And just if I were to put this in context, to begin with, the context of this case is that it's a case in which my Lord Lloyd Jones will recall, in which the court was being asked to approach the claimant's case benevolently and the defender's case critically, because the effect of the defendant's negligence was to deprive the claimant of evidence which would have gone to the key issue in that case. It was a clinical negligence case. The key issue was the claimant's neurological deterioration, and because of the negligence, there were no records. And Paragraph 80, my Lord Lloyd Jones is picking up on the case of Keefe, which the Court's already been taken to. It is a case in which, of course, part of the reasoning of the Court of Appeal centred on the fact that there should have been records of the noise levels. There were no records. There was therefore a breach of duty, and therefore the Court of Appeal was prepared to look at the claimant's case benevolently and the defendant's case critically. And at paragraph 80, my Lord Lloyd Jones makes the point that Keefe is not concerned with the reversal of burden of proof, and he makes that point about clinical negligence cases. And then at paragraph 81, if I could pick up on it, rather, Keefe is concerned with the weight which is to be attached to evidence and the circumstances in which the court may draw inferences. This is how Lord Justice Longmore explained it. He referred to the observations of Lord Diplock in Herrington and British Railways Board that failure to call a witness may result in an adverse finding, and then applied the same principle to a situation where a defendant has made it difficult or impossible for a claimant to adduce relevant evidence. So I emphasise there, it's about the weight of the evidence, and that's then picked up on in paragraph 82, whether it is appropriate to draw an inference at all, and if so, the precise nature and extent of such an inference will depend on the particular circumstances of each case. Relevant considerations will include the proximity between a breach and the non-available evidence, the effect of the other evidence before the court, and what other evidence might have been available but which is not before the court. And the key point that I emphasise from that is that the question of whether to draw an inference, whether it be as a matter of establishing causation or whether it be a matter of establishing breach of duty, is a matter of weighing the evidence and depends on the particular circumstances of the case. It is preeminently a matter for the court at first instance to determine. And that includes, in my submission, the extent of any benevolent approach to the claimant's evidence or a critical approach to the defendant's evidence. Those are all matters of weighing the evidence. There is no overriding obligation to draw an inference adverse to that of the defendant. And indeed, that's, I think, exemplified by the conclusion which my Lord Lloyd Jones reached on the fact of that case, which I needn't take the court to, but from paragraph 83, the court will see that my Lord Lloyd Jones' conclusion in that case was that looking at the matter as benevolently as he could from the claimant's perspective, as critically as he could on the other side of it, he was unable to draw an adverse inference. And it exemplifies that it's a fact-specific conclusion. The second case which I refer to the court to is the case of Ephobe against Royal Mail. It is a case of this court from last year. It was provided as a separate PDF, I think.
Yes, we have it separately.
Do all the members of the court have that available to them? If I may, I think, take the court to paragraph 41 of the judgment of Lord Legate. And to put this in context, it was, of course, a decision on a case regarding alleged discrimination relating to the making of job applications. And one of the questions for the court was the relevance of the defendant's failure to lead any witnesses to speak to the reasons for the selection of other candidates. And in my submission, what is said by Lord Legate is instructive, as he says, the question whether an adverse inference may be drawn from the absence of a witness is sometimes treated as a matter governed by legal criteria, for which the decision of the Court of Appeal in Wisniewski against Central Manchester Health Authority is often cited as authority. Without intending to disparage the sensible statements made in that case, I think there is a risk of making overly legal and technical what really is or ought to be just a matter of ordinary rationality. So far as possible, tribunals should be free to draw or to decline to draw inferences from the facts of the case before them using their common sense without the need to consult law books when doing so. And I draw your Lordship's and your Ladyship's attention to that simply because in my submission it emphasises the point that, again, the thrust of the appellant's position is that that particular inference should be drawn. That is a matter of the facts for the Lord Ordinary. And indeed, at paragraph 42, Lord Legate there says, there is nothing in the reasons given by the Employment Tribunal for its decision in this case which suggests that the Tribunal thought that it was precluded as a matter of law from drawing any adverse inference from the fact that the Royal Mail did not call as witnesses any of the actual decision makers who rejected the claimant's many job applications. The position is simply that the Tribunal did not draw any adverse inference from that fact. To succeed in an appeal on this ground, the claimant would accordingly need to show that on the facts of this case, no reasonable tribunal could have omitted to draw such an inference. And that, of course, is an unsurprising manner of approaching this kind of issue on appeal, that is really the test that an appellant would require to meet in order to overturn the drawing of or the failure to draw an inference in my submission. The third case, and I think I need only mention it because your Lordships have been taken to it already, but it's the case of Drake and Harbour, and in particular I have in mind the dictum of the then Lord Justice Toulson. The case is at tab 8.4, and in particular I would draw your Lordship's attention to what he had to say at paragraphs 26 to 28, which is at page 1509. 1509. And really, in addition to what I've taken already from the two cases I've cited, is that what Lord Justice Toulson says in my submission is that in considering whether to draw an inference adverse to a defender, it may not be helpful to talk about shifting evidential burdens or provisional burdens. It may be more useful to consider it as a question of the overall evaluation of the evidence at the end of the case. It may be harder to draw an inference in relation to breach of duty compared with an inference that there is causation established where there is an established breach of duty already. The extent to which positive or scientific proof is necessary is a matter of judgment. And the way in which Lord Justice Toulson, as he then was, ultimately put it is that whether an inference should be drawn is really a matter of weighing the evidence and ultimately one of common sense. So the reason why I submit, my lords, my lady, why those authorities are relevant to this appeal, and I hope that I'm now going to begin to delve into the matters in which it may be particularly helpful, I hope, to the court. In this case, the burden of proof was on the appellant to establish defect. And I emphasise, and I'll come back to it, the burden was on the appellant to establish a defect in relation to this particular product. Not in relation to the class of metal on metal hips generally, but in relation to this particular product. And I'll come back to that. The appellant seeks to argue that the judge was obliged to make an inference in the appellant's favour as a matter of law, applying benevolence. And in my submission, those authorities to which I've drawn the court's attention identify that the question of whether such an inference should have been drawn was a question of fact to be determined after weighing all of the evidence. It was a matter for the Lord Ordinary on the facts of this case. I accept, of course, that there was evidence which was favourable to the appellant. Of course there was. It is important, and I'll come on in the afternoon to try to distinguish between evidence which was generic and general to metal on metal hips, and that evidence which was specific to this particular product. But there was, for example, evidence that the regulator had issued a notice, and that, in fact, the respondents themselves had issued notice to the effect that this product should not be implanted, and that was entirely accepted by the respondents. But what the Lord Ordinary heard was evidence was that the sole basis for those notices, the sole basis for them, was statistics. Statistics which revealed an apparently high revision rate for this particular product. So that was the sole basis for these notices. And in response to that, the respondents led biostatistical evidence from Professor Platt to the effect that the statistics underlying the alerts, viewed with the benefit of up-to-date information and the benefit of hindsight, were an unreliable basis for assessing that the performance of this particular product was out of line with comparators and benchmarks. And in my submission, as was also clear from his opinion, the Lord Ordinary did not view Professor Platt's evidence in a vacuum. His evidence overlapped and interlinked with other expert evidence. Indeed, a great deal of the evidence did so. And the Lord Ordinary evaluated all of that evidence. And having done so, he concluded that defect was not proven. And the essential submission for the respondent is that the Lord Ordinary was correct in that evaluation, or at very least, it was an evaluation which was open to him on the basis of all of the evidence which he had the benefit of seeing and hearing. The appeal in my submission does not properly raise an issue of law. There is no principle of general application. Rather, in my submission, the appellant's submission amounts to no more than that the appellant ought to have succeeded on the facts of this case. But in my submission, there was nothing on the facts of this case that mandated that mandated the Lord Ordinary to draw an inference that the appellant contended for. Given the authorities I've highlighted, to succeed in my submission, the appellant would face the same hurdle as identified by Lord Leggett, paragraph 42 of IFOBI, to show that on the facts of this case, no reasonable Lord Ordinary could have omitted to draw the inference which was contended for. The appellant, in effect, sought to persuade the Inner House that that inference should have been drawn on the facts. The Inner House, in my submission, rightly did not interfere with the Lord Ordinary's decision, having recognised it was one properly for him to make. And equally, I respectfully submit that this court should not interfere with Lord Ordinary's decision. I wonder if that's an appropriate point for me to...
Yes, certainly. We'll adjourn now and sit again at 2 o'clock.